You find out after it already happened. Your ex left town for the weekend and left your kids with a new boyfriend or dropped them off at a sitter's house Friday to Sunday. And your first thought is the one I've heard from clients for 20 years. Why didn't they just call me? That instinct has a name in family law. You're wishing they provided you a right of first refusal. Whether you actually have that right and whether you can do anything when it's ignored comes down to two things: what your order says and what you can prove. Hi, everyone. My name is Scott Milner. I'm board certified in family law, and I've been trying cases to judges and juries for the past 20 years. But before we get going, if this content is helpful to you, please like this video and subscribe. Okay, so what is a right of first refusal? A right of first refusal is a provision in a custody order that says when the parent who has the kids is going to be away from them for a defined stretch of time, that parent has to offer the other parent the chance to keep them before making any other plans. In plain terms, it puts parents ahead of third parties. It sounds like simple fairness. Time with a parent should beat time with a babysitter. Many people, when they first hear about it, assume it's just the way custody works. It isn't, and that's the first thing you need to understand. Here's what surprises some people. The standard Texas custody order does not include a right of first refusal. When a Texas court enters what's called a standard possession order, or any other order, it tells each parent when they have the children. It says nothing about when you have to call when you can't be there yourself. A right of first refusal only exists if it is actually written into your order, either because the two of you agreed to it or because a judge specifically ordered it. So before anything else, go read your order. If it's in there, we can talk about enforcing it. If it's not, that's a different conversation about whether to go back and modify the order. Now, let's say that you have one. The whole value of it lies in the details. The one people often fight over is the trigger. How long does the absence have to be before the obligation kicks in? Overnight? 8 hours? 24? If you set it too short, you've signed up for a fight every time a dentist appointment or a grocery run comes up. And here's the key. It has to be very specific. A significant period of time is not a number. A good provision also answers a few other questions. Who does it apply to? Any third-party care or just paid sitters? Does grandma count? Does a new spouse count? How does the offer have to have been made? A well-drafted provision requires it to be in writing, never a verbal offer. And how long does the other parent have to respond before you're free to move on? Get those details nailed down and you've got something real. Leave them vague and, well, let me explain. Texas courts will not and cannot hold someone in contempt for violating an order that isn't very, very clear. To enforce an order through the court's contempt power, that order has to spell out exactly what a parent is required to do in clear, specific terms so they know precisely how to comply. So picture a provision that says a parent has to offer the kids to the other when unavailable for an extended time. What's extended? What's unavailable? A judge can't find someone in contempt for crossing a line no one can even locate. So a vague clause gives you the feeling of a right with none of the teeth. Quick reality check, because I'd be doing you a disservice if I only told you about the upside of these rights of first refusal. In a functioning co-parenting relationship, a right of first refusal does what it promises. But in a high conflict relationship, it can become a control device. It hands a combative ex a built-in excuse to demand an accounting of your every plan and manufacture disputes out of ordinary life. Some judges won't even order rights of first refusal for that reason. They've watched it create more litigation than it prevents. So if you're dealing with someone who treats every line in an order as an opening to fight, think hard about you really want to invite that at all. All right, say you've got a clear provision and the other parent is blowing right past it. What do you actually do to enforce it? You file a motion to enforce. And if the violations are clear and the provision is specific, the court has real remedies. It can hold the violating parent in contempt. It can order makeup time to compensate you for what you lost. And in a lot of cases, it can order the other side to pay your attorney's fees. But here's the part that decides cases. Texas makes you plead each violation with real specificity: date, place, and time. Not, she's been leaving them with sitters all year. Each instance. On Saturday, March 8th, the kids were with a third-party caregiver from 8 a.m. to 8 p.m. while the father worked. That's the standard. A motion that can't get that specific is a motion that goes nowhere. And that leads me to the most practical thing I can tell you in this whole video. A parent with a good record wins. The parent needs dates, places, and times. Memory doesn't produce dates, places, and times. 6 months from now, you will not remember whether the weekend your kids were placed with a sitter was the 2nd or 3rd of March, or how long it ran, or whether or not you were offered the kids. So while you're living through it, build the record you'll need later. Keep your offers and responses in writing, never on the phone. A written timestamped offer that goes unanswered is proof. A phone call is a swearing match. Log every suspected violation the week it happens. The date, the hours, who had the kids, and the fact that you weren't offered them. A note made this week beats one reconstructed from memory a year from now. Save the evidence around it, the text messages, the offhand comment about who picked them up, and keep it organized. The whole point of documentation is that you can pull it into one clean, dated timeline that maps your proof onto exactly what the law asks for. Capture it as it happens in a form you can hand your lawyer. Because the parents who walk out of court with makeup time and attorney's fees, they're not the ones with the strongest feelings about being wronged. They're the ones who can put an organized timeline in front of a judge. So, here's the bottom line. A right of first refusal can be a useful provision in a Texas custody order, but only if it's actually in your order, only if it's written in specific terms, and only if you can prove what happened when it's ignored.